I have some foreign nationals that are employed here. Are we compliant? Officers are showing up to work sites and they're asking not the person who filed the petition, not the CEO or the head of HR, but the first employee they see at that location. Hey, have you worked with this person? Do you know what the company requires as a minimum qualification for the position? An extremely disproportionate amount of time that we spend as a law firm with our clients is spent solving problems created by people potentially moving without telling us. Because it's the most common thing that employees do that messes up their status. As soon as they start working from the wrong location, they are violating their status. And you are employing them inappropriately. What about if you're not a small business? You're instead about to found a business. You're an entrepreneur. How do I show that I've got work for 18 months to do? And what's my plan that's going to show to an officer who's never heard of my company because I founded it 3 weeks ago that there's work for me to do 6 months from now? They search your social media and they see on LinkedIn, you've also mentioned that you're CEO of this new idea that you just came up with. That's a huge problem because you don't have an H-1B that allows you to be CEO of that company. My name is Raghavan. I'm a partner here at Serotte Law. I've been working here for about 10 years now. The biggest part of my practice usually is working with companies that are trying to hire foreign national talent or founders who are from outside of the United States that are either building their companies or growing their companies, and so looking for those first few employees. Very often, companies come to us and they ask us the question, hey, I have some foreign nationals that are employed here. Are we compliant? And the answer to that question is kind of different for the different kinds of possible statuses these people are in. So most commonly, if you're a small to medium-sized business and you've hired some people who aren't US citizens or permanent residents, probably those people you've hired are either in F1 status, H-1B status, or maybe O1, maybe E3. So there's a couple of others, but those are the most common. And each of those has slightly different challenges from a compliance perspective. If you're employing somebody in F1 status, they might still be in school. And if they're still in school, then most likely the way that they are employed with you is that they have what we call curricular practical training, so CPT. If you've got CPT, then in order to make sure that you're compliant, you've just got to make sure that they've given you the right documentation to confirm that their employment is authorized by the school. That's what we call an I-20. It's a form that's issued by their school's immigration officer. If they've done that and you're employing them in the right location, and they're doing the kind of job that you actually gave them the offer letter for, then almost definitely they're compliant. If they're in OPT, if they've graduated from school and now they've gotten that year of work authorization that many students do, then compliance is a much easier question, because in OPT, in optional practical training, the only thing that the government requires is that the work that this individual is doing has to be related to their degree. So as long as you've given them a job offer and the work that you're employing them to do is related to what they were educated to do, then you're probably compliant. So CPT and OPT, the question's relatively easy. But then you get a lot of these scenarios where maybe you've hired somebody who's got a degree in what we call a STEM field, right? Maybe in engineering or in data science or something like that. And they're in this period beyond their regular OPT where they've got 2 extra years of work authorization, what we call the STEM extension. In that scenario, there's actually a few more compliance requirements. Even to get that status, you as an employer would have had to fill out some paperwork to say, here's how we're training the person. Here's how we're managing them and measuring their performance and giving them additional training in this field related to their degree. And you have to make sure you're actually following that training plan. Are you compensating them a reasonable amount for the occupation that they're working in. When you said, hey, they were going to have monthly check-ins with their manager, are you actually doing that? And the STEM extension is going to require you at certain intervals during the time period, you have to fill out a review, an assessment of how they did. And if you're not doing that, then again, from an employer perspective, you may not have much jeopardy. But from the foreign national perspective, they're not maintaining their F1 OPT properly because they're not filling out, they're not getting submitted the STEM assessments properly. So that's one bucket of people. Probably relatively common, but another big population of foreign nationals that you may be hiring are people in H-1B status. And the compliance questions there are much more difficult, are much more involved. The first thing is, even as you begin the process, before you've even hired this person, as you go and you file the case, if you're working with an attorney, they'll work with you on this, but you have to define, what do we require for this kind of role? And that question very often is a difficult question for a small business. Maybe this is the first software engineer you're hiring. So when the lawyer asks you, what are your minimum requirements for the position? Almost always, people come back to us and they just say their minimum requirements are whatever this candidate has. So they're about to hire somebody that's got 17 years of experience and a master's degree. So they say, hey, our minimum requirements for the position are a master's degree and 15 plus years of experience. That's an easy answer because you already have that person's qualifications, but that's almost definitely not the real answer. And it's important because how you answer that question is going to dictate how much you have to actually pay that employee. When you say that you require 17 years of experience, you're saying to the government, this is a fully trained, at the top of their field position, right? The government's going to say to you, well, you have to pay them the absolute highest that we require for the location they're working in. That may be a challenge because maybe the absolute highest is $250,000. Maybe it's $300,000 because that's what we call wage level 4 position requires. But if you dig a little deeper, and we find this all the time, and we ask an employer, don't tell us what the candidate has, tell us what you actually were advertising for, what you wanted when you were looking for the position. People get this impression that if they make the requirement higher, they've got a better case. If I tell you that I require a master's degree, I got a better chance of being successful in filing my H-1B than if I tell you that I require a master's. Than if I tell you that I require a bachelor's. And that's just not true. As long as you require at least a degree, your case is going to be just as successful as if you required a PhD. What matters when you're telling your lawyer, what do we require for the position, is what is the minimum you actually require? The government's going to care about that. You can't just pretend for this role, we require this minimal amount, but in fact, your hiring history shows you required a lot more for every other person that you hired in that role. When you submit this petition, the government can't really double check what you're saying. But when they show up to do a site visit, or when there's some question in the case and they ask you for more evidence, now they are going to be checking what you said. In the current administration, officers are showing up to work sites and they're asking not the person who filed the petition, not the CEO or the head of HR, but the first employee they see at that location. Hey, have you worked with this person? Do you know what the company requires as a minimum qualification for the position? And if that person responds, oh yeah, we need somebody that's got a master's degree, and you filed a petition that said, we need somebody that has a bachelor's degree, the government's going to say, hey, look, you guys are lying about this. So when you start working on hiring somebody in an H-1B position, you've got to be concerned at the beginning about what's going to happen after this case is approved and somebody randomly shows up to try and check that these details are true. This question comes up a lot. Does the location that my employee is going to work really matter anymore? Because especially in this kind of post-COVID world, A lot of companies are employing people to do remote work. If you're employing somebody in an O1 status or an L1 status, then it's, the government still cares where a foreign national is, and so they need to be updating their address, but it isn't impacting their eligibility to remain in that status. But for the H-1B or the E3, and the E3 is kind of a H-1B for Australians, for those statuses, it really matters because the law requires that before the company hires somebody in that position, they check how much they're supposed to pay that person based on the location they're going to work. And one requirement that the H-1B and the E3 have is if you're going to hire somebody that's not an American to work in this occupation, then you should first check that you are at least paying them what an equivalent US worker would earn in that location. So if you said when you filed, I'm hiring this person and they're going to work in San Francisco, maybe they're working from home and you don't require them in office, and they'd rather live in Austin, Texas than in San Francisco. These are common scenarios that happen for employers, and increasingly, you might not know as an employer because they're working from home, and you don't necessarily know when they move. If that happens, as soon as they start working from the wrong location, they are violating their status, and you are employing them inappropriately. You're not employing somebody in compliance with the H-1B regulations because they're not working at the worksite location you said they were going to work at. And that's a big problem. And it's an especially big problem right now because if that happens, if that person moves without your knowledge and starts working in Austin, Texas for 3 months and you're paying them there, and then you need to file an H-1B extension or an H-1B amendment, that individual is not maintaining their status. And that means when you file your H-1B petition, your only option, if they really are not maintaining their status, is to have them leave the country, potentially get a new visa stamp if they don't have one, come back to the country after the H-1B has been approved, and then start working. 5 years ago, that would be an inconvenience. Since September, that's potentially a $100,000 problem because that person now is subject to the $100,000 fee. An extremely disproportionate amount of time that we spend as a law firm with our clients is spent solving problems created by people potentially moving without telling us. Because it's the most common thing that employees do that messes up their status. Make sure you're always telling your people, let us know where you are, keep your address active and updated in our HR system, and if you're going to move, you have to tell HR and get approval from HR before you do it. How early should an employee let the employer know if they were going to move in order to ensure that everything can get done to keep them compliant? The first thing I would say is as early as they know, and that would be the nicest thing. But let's say that you find out that the employee is going to move. How long is it going to take you to do what you need to ensure they can move without failing to comply with the rules that are in place? I would say 3-4 weeks. Because what you're going to need to do is you're going to need to update the Department of Labor. You're going to need to file a new H-1B petition. A lot of times when I talk to people, there's an idea or they have this perception that if you're filing an H-1B extension or an H-1B amendment, that is somehow different than if you're filing a new case. And the difference is that you're checking a different box. Everything else about the petition is exactly the same. And by that, I mean exactly as complicated and takes exactly as much time. So when you file an H-1B amendment, it's not the case that because it's an amendment, there's some accelerated or simplified process. You have to follow the same process. Perhaps gathering the details is simpler because you already have most of them. The amount of time it takes to submit an amendment like this is basically the amount of time it takes to file an H-1B petition when you're hiring a new person. The good news is when you file the petition, when you submit to immigration the updated details. As soon as they receive it, you're allowed to start working under the new details you filed. So you don't have to wait for an approval. That's why it may only take 3 weeks, maybe 2 weeks if you can go really quickly. Because as soon as you have a receipt, go to the new location. And then if it takes the government 8 months to review and approve, throughout those 8 months, you are still compliant because you have the receipt notice for the amendment. So what we talked about so far are mostly compliance questions that come up in the context of maybe a small to medium-sized business employing somebody in OPT or in H-1B status. What about if you're not a small business? You're instead about to found a business. You're an entrepreneur, you're going to found or co-found a business. What do you have to worry about in terms of compliance? So if you are here in F1 status, if you are here as a visitor, if you're here in H-1B status employed by some company, nothing prevents you from owning a business. The first thing to understand is doing the things that make you an owner are things you can do before you get your H-1B approved. Doing the activities that would be employment, you can only do after you get your H-1B status. So what's ownership activities? You could form the company, you can open a bank account for the company, you can have a negotiation with a landlord for securing a lease for the company. You could have a meeting with a potential investor who wants to give you money to invest in the company. You could sign a contract for that investment. I mean, these are just general, what we call business visitor activities. You're here saying, I'm an owner, I don't do any active work, I'm not employed, I'm just founding, I'm just creating. But if you want to do product development, if you want to deliver on a contract, if you want to actually start doing the financial analysis that is going to result in you making the investment because your company maybe is a fund or something like that, that's employment. Those kind of activities that you would normally hire somebody else or could hire somebody else to do, that's employment. Those are the activities you want to wait to do until and unless you get your H-1B status. If you're co-founding the company with a US national, a citizen or permanent resident, then that's great. They can be the ones that take that more active role initially, and then you can file your H-1B and then take up your more active role once you file. So that's kind of one half, right? When I speak to people that are in this position, to founders who are trying to now move into H-1B status, very often the most important thing that they are concerned about is, how do I be an owner and have an H-1B? And because of what they've read or what they've seen, they will ask questions about, well, what do I need to do from a company structure perspective? How do I get a board of directors in place? What do I have to have in my employment agreement? Who do I need to have as an advisor? How do I show that I'm really an employee? These are the things that people constantly will ask about. And none of those things matter. Right? Those things mattered in 2024. As of January 2025, they do not matter. But it's still the thing that people think is what's important and what they're concerned about. That's not what you should be concerned about. What you should be concerned about is what the government is concerned about, which is, if you are going to be in H-1B status, are you really going to do the job you claim you're going to do? Does that job really require you to have a degree in some specific field? Is the company actually going to pay you at least what a US worker would be paid in that location? And is there work for you to actually do throughout the time that you're asking? All the same concerns that you would have if you were just working for Google and Google is now hiring you to do a software engineer role. So when you're founding your company and you're about to work in your new startup in H-1B status, it isn't important to figure out, who am I going to put on my board? It's important to figure out, how do I show that I've got work for 18 months to do? And what's my plan that's going to show to an officer who's never heard of my company because I founded it 3 weeks ago, that there's work for me to do 6 months from now? That's the biggest concern, because an officer is going to look at your case and say, how do I know, the officer, how do I know that if I approve this, you're actually going to be a financial analyst for 20 hours a week for the next 18 months? How do I know you're not just getting this approval and then doing other work that's unrelated to this, or getting the approval and then trying to find work? You've got to make sure when you're filing this case, hey, I've got a good plan that shows I'm really going to do this work for this time. Then once you get it approved, actually do what you said. I think we've talked about this before. A lot of people have this idea where, hey, what can I put in a petition to get approved? And I think that is the wrong way to think about it. The question is, what can I do? What can my activity be? How can I behave to be in compliance with what the government is expecting, right? Because then if you're actually doing it, if they open the door and look at you, you got nothing to worry about. You're not just saying something on a petition and then going off and doing whatever you were before. You are actually changing your behavior to do the activity that makes you compliant. That way you've got no stress. What is that no stress? It's if you said you're going to work 20 hours a week, don't just get a pay stub that says you worked 20 hours a week. Keep track of your time. Use a time tracker app. Use a time tracker app that has a GPS location, because then you are, as you are working, creating really good evidence that you're working in the right location and you're working for the right number of hours. At the end of a week, print out that report, save it, print it out. Okay, maybe that's a little bit 20th century. Print to PDF that report, save it in your Google Drive, and keep that record. At the end of 2 weeks, submit those reports via your QuickBooks to get paid for that actual number of hours that you worked. Have your pay stub say worked 23 hours at the rate of $47 an hour. Do the math, get paid that actual amount. That way, you are actually complying with all of the details that you submitted. You're at the right location for the right number of hours doing the right kind of work. In 6 months, if you then decide you're going to move to a different location and you have to file an amendment, or if you get a really great opportunity and you're saying, you know what, I'm going to close this down for now and start working at this other job, and you're then filing a petition and having to prove your maintenance status. Or in 6 months, if some officer shows up and they ask you, hey, prove to us that you're actually working in accordance with the details you submitted, you're not scrambling. You're saying, yeah, sure, here's my contemporaneous records that show you I worked the right number of hours, I worked in the right location, I got paid the right amount. It is so difficult for somebody to question or push back if you have records that you created at the time you were doing the work. On the other hand, if 6 months from now they're saying, hey, prove this, and all you have is pay stubs that just show the exact same amount each bi-weekly period for 20 hours of work, but you've got no evidence that you did anything, and you're now going back and you're saying, well, let me give you a report of what I did that I'm creating today from my memory of what I did 3 months ago. And that's really poor evidence. It's very easy for them to question that and say, well, you're just making this up now. But it's very hard to question it when you actually created it in January when you were doing the work. So I would say the biggest thing for a founder to be concerned about in H-1B status in terms of compliance is keep contemporaneous records to show you're actually doing the work for the amount of time you're supposed to be at the time you're supposed to be doing it. Then you're in a really good position. There's another aspect to this compliance, especially when you're working in H-1B status, and that is in order to get the H-1B petition approved, either the company or you as the company had to define a job and tell the government which of the government's standard occupations is this job most closely related to. I got a whole list of these things. And you say, hey, this is most closely related to software developers or to financial analysts or to management analysts or whatever it may be. What you are doing should match what the government expects somebody in that occupation to do. It's very important as your job evolves to make sure that you're thinking about, hey, what did we say I was going to be doing? Am I actually doing that? If now I've changed, if my responsibilities have increased, if I started out working as a software engineer, but now I'm doing much more of the mechanical engineering aspects of this robotics position or something like that, then that's important, because a different job means potentially a different standard occupational classification, means potentially a different required salary. And the government would say that's a material change. That's a compliance issue, because when an officer shows up at your work site and says, hey, what do you do? And they're not just gonna ask you, they're gonna ask other employees, other people who are working there, and potentially gonna ask for proof, so you might need to show work product. And you look at this and say, hey, look, really, I'm doing this engineering manager work, but you said you were an electrical engineer. That could be an issue. Increasingly, the government's also looking at social media. Right? They're looking at what you put out in the world about what you're actually doing. So let's say that you have a trip for Christmas to go visit family. You go visit family in Brazil, you're flying back to the US, you're coming in to be readmitted in H-1B status, you're a software engineer working for a company. And when you go up to the officer at the airport and he says, hey, what's your purpose for entry? And you say, hey, I'm an H-1B employee. Here's my visa stamp. Where do you work? Oh, I work at ABC company as a software engineer. And they search your social media and they see on LinkedIn, you've also mentioned that you're CEO of this new idea that you just came up with. And you're trying to do that. You're trying to put it out there because you just founded a company and you're trying to bootstrap something and make it work. You're not yet doing any work for it. You're just trying to see whether this is an idea that could work. And so you're putting it out on social media because you want to see if you can get some traction. Well, that's a huge problem because you don't have an H-1B that allows you to be CEO of that company. You're currently an employee of a different company. So an officer could look at that and say, you are saying that you're doing this other employment that you're not actually authorized to do. And they could conclude either that you're lying to them, which would be really bad, or that you've worked without authorization in the past. And they could deny you entry or find that you were committing fraud.